Thank you. And Bruno, we're going to move with that sort of question, but we're gonna get a little bit more specific, and this relates to student accommodation leases. So there are a number of people who write in about student accommodation that want to know about this, and what they want to know is, what are the key elements of a student accommodation lease? Are there any differences or similarities with regards to your normal lease agreements? What are the intricacies surrounding that area?
When approaching student accommodation and leasing, I think it's important that we take a step back and realize that the rules around leasing aren't that different from the general rules around leasing in the property space. So with investors that are investing in student accommodation and might fear or feel overwhelmed by the information that they received around students and leases and what the expectation is and how the student pays and what sort of security you need to have, I think it is important to first take the step back and realize that they governed by the same principles, they're governed by the same laws, they look the same, right? If you're entering into a lease directly with the student, the same principles in our law apply. Now, we can spend a lot of time going through these basic principles, but I'll just give a quick overview now. And these relate typically to, for starters, the actual essentials of a lease agreement. A lease agreement can only be concluded and be of effect if there's something that's being hired out. So somebody actually takes use of something and they're entitled to use and enjoyment over that thing, but they don't have ownership over it. So they do have to give it back after a period of time. And so it's temporary use and enjoyment. And in exchange, they will be paying rent, which the landlord would then receive. So these typical rules apply across the board, whether it's movables or whether it's immovables, these are all the same. And for a lease to come into effect, there has to be that item or that thing that's actually being hired out and a rent in consideration, right? So that's the one aspect that you need to remember. Now, do lease agreements have to be in writing or can they be oral? Now, oral lease agreements, totally acceptable. There is nothing wrong with them. In the normal scope in the property space, you are entitled to enter into an oral lease agreement. However, even though legally speaking, there's nothing wrong with it, it is the worst idea. Please, I have to say this over and over and over. It is the worst idea. You need clarity on the terms, the expectations between yourself as a landlord and the tenant. The tenant needs it, and you as a landlord need it too. So please make sure that it is in writing. At least in writing, you have a basic understanding of when the renewal periods are coming in, what the anticipated escalation will be, what the responsibilities of a tenant will be, what the responsibilities of a landlord will be, who fixes what, who pays for what, how much do they contribute. Now, again, there's certain nuances when it comes to student accommodation, because very often with student accommodation, that's why I'm popping this in here now, is with student accommodation, you often find that it is a multi-let environment. So again, multi-let isn't restricted to students only, but so you do find very often that students live in a multi-let environment. What does that mean? It means that they either have individual rooms in a certain property. Hell, they could have individual rooms, individual kitchens, individual bathrooms. But typically speaking, you find one landlord with multiple tenants. And whether it's a house with multiple rooms, whether it's a digs, whether it's student sharing rooms, or whether it's like a block of flats where every student has their own room. Bottom line is there's always a level of shared consumption or shared space. And because of this, it's very important that in the lease agreement that the tenants know what their rights are against other tenants, know what their rights are against the landlord with respect to other tenants and that shared space. And especially when it comes to the contribution of charges like electrical charges, use of water, sewage, or sanitation, that sort of thing. Tenants are often tenants often find themselves in a position where they're liable to contribute towards these charges. So you'd obviously want to have an understanding on what percentage you're paying versus the whole. and whether this is feasible or not. Because the last thing you'd want, and I mean, this is a very strange example, but it relates to my commercial property where I run my office from, where in the building that I have my office, there was actually a culinary school above. And I got into a conversation with the landlord about the pro rata division of things like electricity, knowing very well that this is what they spend their day doing versus my office, which only uses, especially water consumption, only uses water, probably for coffee and very minimal use, like washing dishes from time to time. Whereas that school would obviously be using water for the entire day, and they'd have a lot more dishes than we would. And it's logic like that applies, where a landlord needs to be able to defend a charge, and a tenant is going to be asking about the charge. So going right back, having it in writing is crucial. If you don't have it in writing, it is still enforceable. Proving it becomes an issue. And this goes to the conversation about implied lease agreements or tacit lease agreements, where you and a tenant have a conversation, the tenant pays a deposit of maybe first month's rent, and you hand over the key, and the tenant moves on to the property. Guys, that is a lease agreement. For all intents and purposes, you have entered into a lease by doing that. Unfortunately, you don't have any more details around what that lease could actually entail. There are examples or instances where if a lease does get sent over, let's say via email, and the parties conclude this agreement orally and hand over keys, there have been cases where it's accepted that the tenant moved in knowing that those were the terms, and knowing that those were the terms, they still elected to move in, and the landlord still allowed them to move in. So there is some basis to rely on some of those terms in order to make out a case of that being the elements of the lease agreement. But so just bear in mind, entering to a lease agreement can be very easy, and unfortunately dangerously so. But lease agreements in the student space look very, very, very similar to lease agreements in the normal space. Now, just to wrap this up with one more observation. If you're entering into a lease agreement potentially with the university directly, or some other kind of service provider that takes over the responsibility over the property and themselves places students onto that property, that is a very, very different conversation. Because you're not in theory entering into a lease agreement directly with the student or multiple students. You're entering into one lease agreement for one entity to actually lease the property to students. So that is something to bear in mind, is in theory, those lease agreements do look very different to your normal residential lease agreements. And last thing, remember that if you are entering into residential lease agreements, the tenant is entitled to ask for it to be in writing. So you may very well find that at the end of the day, you've handed over the key, the tenant's still entitled to put up their hands and say, give it to me in writing, and you must do so. So those are just a couple of small little bits of information regarding leases and how to look at these in the student accommodation environment.
Perfect. Thank you, Bruno, and we will see you next week.
Awesome. Thanks, Nick.
Thanks.